Great. Thank you very much for having me. It's a real honor to be here. So, as everyone was saying, my name is Brad Haywood. So, I currently only have one job. So this is a new development for me. For the past 5 or 6 years, I've had really two full-time jobs as both the chief public defender for Arlington County and the city of Falls Church, and also the executive director for Justice Forward Virginia, which is a criminal justice reform advocacy group. I say I don't have the second full-time job anymore because I'm now a board member. We hired another executive director, so a little bit of a burden off of me, which has been refreshing. But of course, what do they say? Water always finds its level. So somebody who is a workaholic like me on these issues, I'm making myself busy regardless. But I just wanted to initially. There was a question about my background. I thought I would share that with you first, and also I just mentioned I don't want to drone on here. I know you all probably have many questions about criminal justice reform locally, statewide, nationally. I'm happy at any point to stop and answer those questions. I often find that these sorts of events go better when they're a dialogue. But just to kick things off and let you know how I ended up where I am today. So I actually grew up, I was born in Michigan, but grew up in Northern Virginia. So I grew up in Great Falls. I went to Langley High School. Then I went off to University of Michigan. That's where my family is from. And a lot of us went to University of Michigan. Went there and I started thinking about my career. I knew I wanted to help people for a living. I actually had wanted to be a doctor when I was in undergrad. Then I checked my transcripts in my junior year, and I saw that I was really, really bad at science classes. And then it also dawned on me, I don't know, it hadn't dawned on me earlier, but it also dawned on me that I really hated them. And that's a pretty bad combination for a doctor when you both hate the thing you're going to be doing and you're really bad at it. So then I looked at like the other portions of my transcript, like philosophy classes and things like that. I'm like, oh, I'm really good at this. Like I barely even tried in those philosophy classes. I did real well. So I was kind of stubborn, but I pivoted towards becoming interested in the law. And actually, I think kids these days, I notice from like being a hiring manager for interns, I've noticed that kids these days they learn way more when they're in high school about future and like career plans and stuff. When I was growing up, I didn't know anything. I frankly didn't even know a lawyer could do good in the world. That sounds ridiculous, but until I was 20, 21 years old, I just thought lawyers were people who, whatever, they had a bad reputation for honesty and they cost a lot of money, so forth and so on. But I just had some life experiences, which obviously helped me grow up and learn how you can make a difference as an attorney. So I started applying to law school. I took a year or 2 years off after undergrad, and I started applying to law school. Eventually, I got to law school, and I treated law school as a process of trial and error, determining where I would fit in the best in the legal field. And my criteria were basically, what am I going to be? What am I good at? Like, where my talents lie? What do I really care about? And what am I going to be able to do every day for the next 15, 20 years? And just being somebody, I can be a bit scatterbrained, a little bit ADD. Through all the various internships I had, I found that the internship with the public defender's office was the most energizing. And it also was just something that as soon as I started learning more about the criminal legal system, unless you don't have a heart at all, there's no way not to be struck by the profound injustice that occurs on a daily basis in criminal courtrooms, especially in Virginia. And so that planted a seed in me. Not only did I recognize this could be a career for me, but I think what led me to that field was, like I said, a passion for serving disadvantaged people, and specifically poor people. But the more you get involved in criminal legal reform or indigent defense, the more it honestly becomes about the system itself and just the profound injustice that occurs, like I said, on basically a daily basis throughout the Commonwealth. So I finished law school, and it's very difficult, actually, something you may not know, for public defenders to start their careers, because there are almost no public defenders in the entire country, public defenders offices that will hire you straight out of law school. You actually have to decide where you're going to live. You then have to take the bar, and then you have to hope that when you get your bar results back, that there will be an opening at some public defender's office nearby, and that they'll hire you to work there. We're not like any other state agencies or federal agencies where they can plan for openings and they know they're going to have a certain budget to hire certain positions. Public defenders aren't like that. We can only hire when we have openings in the office. I was fortunate though; I didn't have to work for long on as a contract lawyer, and then I was hired to be a public defender in Alexandria, where I worked for 8 years, and then I went into private practice for a brief period of time. And it wasn't necessarily because I wanted to make a lot of money. It was because I kind of felt maxed out in terms of what I was learning in my position at the Alexandria Public Defender, and I needed a new challenge. And specifically, I wanted to work on death penalty cases. So I joined my two former law partners, John Sheldon and Joe Flood, both premier capital defense lawyers in Virginia and nationwide. And as I joined that firm, actually, this is interesting. A good thing for the world, a bad thing for Brad's professional development was that Virginia was stopping using the death penalty quite as often, and that was actually largely because of actually capital defenders doing such good work and preventing people from being executed. But as a result, a large part there was a part of my practice that was capital defense, but even more of it was just ordinary court-appointed work and some private defense attorney work. But this gets me to the present day. And how did I end up with starting Justice Forward and in my current job? So I think you probably all, I don't know, actually, I don't know your familiarity level with state level politics. And I don't know everybody's politics or ideology here. I personally found that regardless of what political party you are, where you are on the political spectrum, people just aren't really aware of how much state politics and state governance matters. We live in a Commonwealth of Virginia. There are 8 million people who live here. If I'm able to change one law, I change a law for 8 million people. That's the size of a lot of countries. And, I tend very far to the left. Our issues are bipartisan. I tend to be very far to the left. I think personally that especially people on the left and the liberals and leftists have really ignored state legislatures and state government, and we're worse off for that. But I started to become aware of this in my role as a criminal defense attorney. Because here's what would happen. This would happen every single year. For those of you who don't know, Virginia has their legislative session once a year, and it's either 45 days or 60 days, depending on the year. This year is 45 days. And all of our legislators are expected to be part-time. You know that none of them actually are. They all kind of treat it as a full-time job. But regardless, there's one period of time, a month and a half to 2 months a year, when all of the laws for Virginia get made. And every year, as a criminal defense attorney, right around February, on our lawyer listservs, lawyers have these listservs, email listservs where we get whatever people asking questions about cases or this issue or that issue related to criminal law. Well, there's one criminal defense attorney in Virginia, Scott Survell, who's also a senator in Virginia. And every year we would get a panic, like at least one panicked email from Scott Survell, and the panicked email would be something to the effect of, there's this terrible bill that's making its way through the Courts of Justice Committee, and it's going to go to the floor of the House. And all you great defense attorneys need to call your legislators immediately because this has to stop. You have to put it under this. It's a terrible, terrible law. And we'd all do our duty and pick up the phone, write our emails, call our legislators and say, hey, don't pass this. But just after about, 7, 8, 10 years of getting these emails, it was just like, why am I only hearing about this now? Like, why didn't I hear about this 12 months ago? And furthermore, why aren't people on our side, like working on bills that would get prosecutors or the police to send panicked emails to their listservs, And it just seemed like there was an imbalance. There was nobody really working on criminal justice reform as like their full-time job or really paying sufficient attention to it. And I just being sort of a doer, I started looking into it. And I started thinking where, I knew who the so-called tough on crime lobby was in Virginia, and that's the Virginia Association of Commonwealth Attorneys mainly. But I was like, where's the counterweight to the Virginia Association of Commonwealth Attorneys? So I started snooping around, and lo and behold, I found there was none. There was no single organization in Virginia that made criminal justice reform its only business. So you had this massive imbalance in power in Richmond. You had the so-called tough on crime lobby that sort of had their way, like with criminal justice legislation. And then you had groups here and there, like ACLU Virginia would get involved in some issues, Legal Aid Justice Center would get involved in some issues, but it really would only be here and there. And frankly, most of the people who were involved in that didn't really have a great level of expertise when it came to criminal justice reforms. They didn't have any frontline experience, and they didn't have any lived experience. So just the policy making of it being kind of a mess. And even when they would get involved, a lot of times they wouldn't be successful. So me being me and my friends being my friends, I started Justice Forward Virginia. I'm like, hey, we're going to do this. We're going to go down to Richmond, and we're going to be the ones who push back. We're going to be the ones that help get the legislature valid information, like true information about our issues and what's really going on in criminal courts in Virginia. So long story short, we had some different choices about how we organized. Eventually, we ended up being a 501c4, a nonprofit. And eventually we found that our niche was going to be specifically legislative policy advocacy. And so we started small the first few years. We started to get some traction in terms of developing relationships with various legislators. And also we got a couple of bills passed in I think the second and third year that we were an organization. And then 2020 hit. And I think we all know what happened in 2020. I mean, it was I don't know, maybe the craziest year I've ever been alive. You have both the pandemic, and then you have this historic civil rights movement that's based around criminal justice reform because of the murders of George Floyd and Breonna Taylor. And this could not have been more serendipitous for our organization and for the General Assembly, because right at that same time, like I said, we had been gaining credibility as an organization, and we had already, probably a dozen different bills we'd already drafted and proposed. And so Virginia, after these civil rights protests are going on, the legislature decides, and they had a trifecta: Democrats in the House, Democrats in the Senate, Democrat in the governor's mansion. And so they called a special session. Part of it was for COVID stuff. The other half, probably actually more than half eventually, well more than half, was criminal legal reform. And so we were ready to go. And we had about, like I said, a dozen bills that we had carried during that special session. And it was all stuff, by the way, we talked about how Virginia, so a couple things. First of all, and we can discuss this more if you have all questions about this, but we saw a big difference between what the national narrative was. The national narrative about what happened to George Floyd and Breonna Taylor was that this was a matter of police not being kind enough or gentle enough or not being respectful enough. And people always refer to that as police reform. And we never viewed it that way. I know a lot of police officers, many, thousands probably over the course of my career. Actually, I don't think most cops are bad people. I think most of them get into that line of work because they truly want to serve their communities. The fact of the matter is, though, they have too much power. So anybody who has too much power, they're going to abuse their power. And so if you're going to address abuses of power, you need to address the power itself. And you have to, that's not police reform, that's criminal justice reform. And it's the reality of the situation is we have too many laws with too harsh sentencing policies, and there are too many people in jails and prisons, relying on jails and prisons, arrests and prosecutions and prisons to solve social problems, and we shouldn't be doing that. So unlike a lot of states, which really focused on stuff like, use of force standards, or, eliminating chokeholds, or implicit bias training for police, we didn't, honestly, I'm not gonna say we didn't care about that, but anytime anybody brought that up with me, I'd be like, you know what? Okay, cool. Like, that's not gonna hurt. But if you really want to solve the problem, we got to do something more than that. So that was the first thing I was going to say. The second thing about this is that in terms of Virginia's criminal legal system, we'd always talked about as Justice Forward Virginia as we were in the stone ages of criminal justice. So, and issue by issue, you would go down the line, and that was absolutely true. And I'll give you a couple examples. So first of all, Virginia was one of only 2 states that had a practice called mandatory jury sentencing. Mandatory jury sentencing was just a procedural mechanism whereby a prosecutor, they could demand a jury trial, and because Virginia has to, Virginia had jury sentencing at the time, essentially, without getting into all of the legal details, they could have weaponized this process of jury sentencing and turn cases where there were no mandatory minimums into de facto mandatory minimums. And it would essentially coerce people into pleading guilty, Or if they took their cases to trial, they would just be rolling the dice about whether they were going to get some kind of extreme sentence. So we were only one of 2 states, the other state being Kentucky, that still had mandatory jury sentencing. We also one of only 2 states that had a law called interdiction, which is also known as the habitual drunkard law, which is unbelievable. What the habitual drunkard law said was, if a prosecutor, they could go to court and they could just petition the court. There were no real specific standards about this. They could just go to court and they could say, Judge, I want you to declare such and such Joe Smith. I want you to declare Joe Smith a habitual drunkard. And if the judge did that, the judge would always do that. Then anytime Joe Smith was found in possession of alcohol or attempting to purchase alcohol or intoxicated in public, he could be put in jail for a year. I'll tell you, the only people who were ever outside of Virginia Beach, which is just basically like Westworld or something, outside of Virginia Beach, the only people, and in Virginia Beach, it was a lot of people who just party all the time and get interdicted. But everywhere else in the Commonwealth of Virginia, the only people who would get interdicted were unhoused. So it was a law to criminalize drinking by homeless people. You think about it, like if you are somebody who is, if you have alcoholism and you have money and you have a place to drink, you're not going to drink outside, like on the sidewalk out in front of the, Arlington County government building, like you're going to drink at home. And so the only people who weren't doing that, especially when they're faced with a year in jail, were unhoused people. So we had that law. We also had a law, petty larceny third offense law, where, and this was also only homeless people would be charged with this, almost 100%, I think, were probably unhoused people. But it said that if you'd committed 2 prior petty larcenies, could have been like, I had a case recently, this guy, he's still on probation for this petty larceny third felony offense. He, on one occasion, had stolen chips in a drink from a CVS. On another occasion, he had stolen air freshener. Third time, he was stealing food from 7-Eleven, but he was charged with a felony for that. And then he got a 2-year suspended sentence for that. And because he was unhoused and had behavioral health problems, he ended up serving almost every day of 2 years in prison for theft of a total of maybe $30 of goods. And the reason he was stealing, and the reason he was the same reason he was homeless, he had serious mental illness. So he was diagnosed with schizophrenia. So like nobody bothered to invest in his treatment or in his housing. What they bothered to invest in is a cage in which to put him. So, understanding we had these laws that gave police and prosecutors so much power, that was what we described as the Stone Ages of criminal justice. And so our goal was, let's take us out of the Stone Age. Let's get, or let's get out of the Ice Age and get kind of the Stone Age. Like let's get to the Bronze Age. Let's like move it up a little bit, and maybe someday we'll be kind of close to normal. And fortunately, we had a tremendous amount of success. So, and not only with this stuff that was sort of like Stone Age of criminal justice sort of stuff, but even we ended up in the 2020 special session doing some really making some really interesting and kind of cutting edge progress. I'll tell you about one issue in particular that I'm very passionate about. So, you may or may not know, I don't know if anybody's heard the term pretextual policing. You may not have heard that term, but you probably heard the term racial profiling, or you may have heard the term driving while black. So this is a thing. This is, I think we all know, because we've seen the videos. We've seen the videos of, Philando Castile or Dante Wright, Walter Scott, or, there was no video of Sandra Bland, but there was also in Virginia, there was the Lieutenant Karen Nazario in Windsor. You all know that this happens, that people get pulled over because of the color of their skin, and then bad things happen. Well, there's a reason you keep seeing that over and over, and that's because that has become basically the most fundamental aspect of American policing. The number one reason that police interact with community members is because of traffic stops. So and that has increased more and more and more over the years. It's almost half of police citizen interactions now are traffic stops. And it isn't just because police are really, really obsessed with traffic safety. They really aren't. It's because of a Supreme Court decision, Wren versus United States, which was in 1996, and Wren versus United States. And this is a paraphrase. I'm not exaggerating here. What it said was the police can pull over black people because they're black. That's what it said. It said that there is no, the Fourth Amendment says nothing about the subjective motivations of a police officer. So the subjective motivations of a police officer are entirely irrelevant under the Fourth Amendment, according to Wren. So that literally means as long as they have a cover story in the form of one of hundreds, if not thousands, of traffic infractions or pedestrian infractions, as long as they have some cover story, they can pull somebody over for whatever reason they want. It could be explicit racial bias. They could even use racial terms. They could use derogatory terms during that traffic stop without violating the Fourth Amendment. It's really that bad. And so if you wonder now why you see that in Virginia, Black motorists are nearly twice as likely to be pulled over as white motorists, and they're nearly 3 times as likely to have their vehicles searched as white motorists, it all kind of makes sense because that's what the law allows. Like the Constitution sanctioned that. It is understandably one of the main reasons that I think there's so much distrust between police and people in communities of color, because they know they're being policed simply based on what they look like, and they are. And anyway, and also, from our perspective, if you reduce the number of unnecessary interactions with police, you're necessarily going to reduce the instances that could occur where it devolves into like something violent, where there's abusive force or use of excessive force or death while in interacting with a police officer. So Virginia actually, in a bill that was patroned in the House by Delegate Hope, we became the first state, and this was a bill that Justice Forward wrote. I helped write it, and our policy director also wrote it. We became the first state to place any limitations on this practice known as pretextual policing. And what we did is we chose the infractions that were most likely to be abused by police. Things like in Virginia, goes back to the whole Stone Age conversation. In Virginia, until March 2021, any Virginia police officer could pull you over for having air freshener hanging from your rearview mirror. So what they would say was that obstructed your view out of your windshield. Now, never mind the fact that you've got a little visor that's about 10 times the size of an air freshener that you can pull down. That apparently is not illegal at all. But they could, if you had one of those, it was carte blanche for police. Anytime they see somebody with an air freshener, rosary beads for another one, they could pull that car over. They don't care. They quite clearly do not care about the obstruction of someone's view. In fact, this issue had been litigated in the Virginia's appellate courts, and statistics were even presented by the appellants in those cases. And it was something like 99.65% of the windshield would still be visible to a driver if they had air freshener. And what the Virginia Court of Appeals and Supreme Court said was, that might be it, but a police officer might still have probable cause to think that it's obstructed. And so they upheld the practice. And so it was stuff like that was the only time as a criminal defense attorney you'd ever see that offense cited is when it was used as a pretext, because a police officer wanted to pull somebody over, usually because they were looking for drugs. Like, by the way, who cares about drugs that like simple possession of drugs that much that you're willing to put someone's life at risk during a police stop? Like the whole notion that we're doing this because of the war on drugs to begin with, like that's another conversation. I could get into that also. But it's these vehicle equipment violations that we mainly targeted through the pretextual policing legislation. So getting rid of those, not so they're not illegal anymore, but so they can't be used as pretexts. So like things like having your license plate tag light out. I don't know if you all know this, but everybody has these two little tag lights above their license plate. In Virginia, another one that this was another reason you could be pulled over. If even one of those tag lights was out, a police could pull you over at any time. It doesn't matter how well illuminated your license plate was by your brake lights or anything else. It doesn't matter if it was daytime. Police officer sees one of those tag lights out, they had carte blanche to pull you over. There's a whole list of about 20 things kind of like that. And they were made to be secondary offenses. So people can still be ticketed for them, but they have to be pulled over for something else. So again, we became the very first state in the whole country to place any limitations on pretextual policing. And since then, you've seen a lot of cities and other states attempt to do the same. Philadelphia passed an ordinance that was almost identical to our state law. Pittsburgh just passed an ordinance. I believe San Francisco just passed one, their police commission. There's states like Minnesota and I think it was Massachusetts that tried to pass legislation, but it's still pending. But it's like fantastic stuff. But like, as I was saying before, I don't know that I was fully saying this, but like there's just a lack of information about things that matter. The things that are going to really make a difference to reducing racial disparities, to reducing mass incarceration. So, in my opinion, as a criminal justice or criminal defense attorney, pretextual policing is maybe the most egregious police practice in the world. But I don't know, probably 90% of people don't even know what that is. And so your challenge as a group like ours is to educate people first, and even educate the legislature, and because even them, you'd think that you've got 140 elected officials. I mean, they're in Virginia, 100 delegates, 40 senators. There might be 5 in the entire legislature who really understand our issues. So our fight is as much to inform them as to inform folks like y'all, like people who really care about this stuff, also just don't really know much about it. But the more we do that, and we take the focus off of like fear mongering, which it was very prevalent last year, especially before the midterms, with various elected officials blaming short-term increases in crime on certain things that really had no impact on crime rates. People latch onto that and they don't hear the more nuanced takes, the complexity of the issue, the things that really do make a difference, the ways we can make our laws better and our communities healthier, safer, and more equitable. So that's my long 20-minute spiel about kind of where we've come from, where we're at. And by the way, also, if you're interested in local issues, I could tell you another 20-minute story, probably 20-hour story about evolution of Arlington's criminal legal system, because you may remember this from 3 years ago. When last time there was a Commonwealth Attorney's election 4 years ago, we were as backwards as anywhere in the whole state of Virginia, and we've made a ton of progress since then, and even a little bit before then. But we are in many ways sort of like I don't know. We are like the paradigm of sort of a blue jurisdiction that embraces these issues. And what do we do about it? Like, how do we implement it? And how does the community feel about it? So if you have any questions about that, I'm also happy to answer those questions. So
I have a question here. Do you have any statistics on how those changes to pretextual policing laws have affected traffic stops and incarceration rates and the whole criminal justice system?
Sure. So actually in November of 2021, NBC, like the national NBC news outlet, did a pretty comprehensive long form story about pretextual policing, and they focused on Virginia and our effort to get those laws passed. And what they found, it was traffic in general has been different because of COVID. In 2020, people really weren't driving at all. In 2021, people were starting to drive more. So it was difficult to compare to a baseline. But what they found was that in the 8 months or 9 months after the law was enacted, so stops of Black drivers had decreased by 40%. Stops of white drivers had also decreased, but had decreased by a smaller amount. So the racial disparities were narrowing. That narrowing has expanded a little bit more. We anticipated that would happen because we just thought police would find new favored pretexts to use. So that has definitely happened. And then remains a very bad racial disparities in traffic stops and searches, but it has helped. And more than anything else, I think it's helped move the conversation forward. So we always viewed that as a first step. And so there are subsequent steps that can be made. Like, I think a lot of people in 2020 talked about why are police even involved in traffic enforcement? Good question. A lot of places have actually tried to create civil traffic enforcement agencies. Like Oakland, California, I know did that. I think Minneapolis tried to do that. But what they quickly found was that state law prevented them from doing so, because most states have a law that says only sworn uniformed police officers can conduct traffic stops. But I mean, that's where we ought to get. If we're dealing with traffic safety, it should be about traffic safety. It shouldn't be about fishing expeditions for trace amounts of cocaine or something. I would also, just while I'm on this topic, something that a frequent response from the Tough on Crime folks is oh, we also need this. They used to talk about it as traffic safety. They know it's not an issue of traffic safety because actually it should enhance traffic safety, because instead of focusing on these BS sort of stops, now police, if they're going to be out doing traffic enforcement, the stops they're going to make are for actual dangerous driving conduct. And this is actually, so Fayetteville, North Carolina in 2013, a police chief there decided they were not going to do pretextual policing anymore either. And what he said was, so stop doing these pretextual stops, focus on actual dangerous driving behavior, and then we'll see how it goes. And they did it for like 4 or 5 years. They found that actually, first of all, violent crime didn't go up at all, but traffic fatalities decreased because they weren't pulling people over for like air freshener or tag lights anymore. They're pulling them over for reckless driving or drunk driving or improper driving, whatever, driving conduct that would endanger people. And I think there was also a recognition that it's just incredibly inefficient to try to locate contraband during a traffic stop. There was a 2018 study by a University of North Carolina professor, Frank Baumgardner. He studied 24 million traffic stops, and he found that an illegal weapon was found 1 in 1,000 stops. And, even drugs, 1 in 200 stops. So like, is that a really good use of resources? Aren't there better ways? We're worried about gun violence or something. I think there got to be way better ways, especially in an era of data, than dragnet policing where we're pulling over thousands of cars just to get one gun off the street. Long answer to a short question, but there you go.
Is pretextual policing common throughout Virginia, or are there areas where it's more prevalent and areas where it's less so?
I don't think it, I think the only difference is it's the bread and butter of every single police department in the whole country, full stop. I think that where you find the differences is in how explicitly racist it is. Wherever it is, it's going to be informed by serious implicit bias. But whether it's explicitly racist or not is really the question. And so I'll give you an example of that. So I mentioned the video of Lieutenant Karen Nazario in Windsor, Virginia. Well, after that happened, and it was about 2 years ago when that video became public, and he was driving for an expedition, and he was pulled over for supposedly having dark tint. His tint wasn't illegal on his car, and also for not having a license plate displayed. He had a license plate displayed, and then when his vehicle was pulled over, you had these 2 turbo cops who just started shouting at him, and they eventually pepper sprayed him, even though his hands were outside of the vehicle, and he was like, "I'm afraid you're going to shoot me." They pepper sprayed him, and then he had a lawsuit. He won the lawsuit, but he didn't get much damages. Anyway, shortly after that took place, at the time, Attorney General Mark Herring announced a lawsuit against the Windsor Police Department. And what he, I actually have a quote from him. What he said was, while our investigation was spurred by the egregious treatment against Lieutenant Nazario that we all saw in body cam footage, we discovered that this incident was indicative of a much larger problems within this department. Our months-long investigation uncovered huge disparities in enforcement against African American drivers and a troubling lack of policies and procedures to prevent discriminatory or unconstitutional policing. And he was suing based on a violation of Virginia Human Rights Act and the Virginia Public Integrity and Law Enforcement Misconduct Act. So you have some jurisdictions that are just super racist, where they are probably even openly talking about the color of the people they're stopping. Then you have places like Arlington. Like Arlington is a very professional police department. We're going to have the same racial disparity. We definitely have the same racial disparities here. Like I can give you the data on that. But it's not, most of the cops here aren't going to talk. They're not going to use the N-word. So like, it's really the only functional difference. And practically speaking, that's no difference at all, because people are still being arrested for nonsense, and they're having their communities harassed. So.
Next question is, how do you get reporters to understand what's going on? You talked earlier about giving a long answer to a question and having it cut down to, a tiny little sound bite. Are there journalists who cover Richmond and county issues better able to explain these complex challenges? Where do ordinary people like us go to get clarity at what's at stake here?
It's really difficult. In Northern Virginia, for a while, the Post had a couple of beat reporters who were doing a good job. Now, So nobody likes being on the crime beat forever. And so, like, for example, Rachel Weiner is a writer for the Post. She used to cover Arlington and Alexandria crime beat. Very good writer, really thorough. All her pieces were always super informative, but she didn't want to keep writing about that stuff. It just is kind of a drag. So she moved on to something else, like she was promoted. And now they put the person they replaced her with really doesn't seem to be very interested at all in criminal legal issues. It's like, at least, you know, the kind of like structural issues like this. I think that person more will report on individual cases. But then you also have people who are actually trying to exploit fear and misinformation. Like there's this guy on WJLA, Nick Minock. He's the one who's totally obsessed with the Loudoun County School Board and all that stuff. Like every time he opens his mouth, it's just false. And you know, they're a Sinclair station, so I mean they traffic in misinformation. But like last week, he was trying to expose Steve Descano in Fairfax for using this Signal app for texting. And he's like, oh, this is so, and like he's saying how this organization, Virginians for Safe Communities, had filed a bar complaint against Steve Descano for using Signal. And I'm sitting there thinking to myself, because I'm on Signal, my office uses Signal. Every time, and I haven't been in private practice, I probably have the cell phone numbers of about 8 or 10 Fairfax County police officers. Every time one of those police officers joins Signal tells me. So it's like my response to that on Twitter was, hey, guess who else uses Signal, Nick Minock? Like the Fairfax County frickin' police department. Like this isn't a story. This is just and every single member of like the Arlington legislative delegation, like every politician you know is on Signal. And then besides for that, also he's talking about a bar complaint. Like as a lawyer, to any lawyer who heard that report was like just rolling their eyes, because anybody can file a bar complaint. First of all, 98% of them are just dismissed without an attorney even being notified. What Descano did was not a violation of legal ethics. It may have been a violation of FOIA, but there's a specific remedy, and that's a writ of mandamus. And like these guys didn't even know that the writ of mandamus was the thing they should pursue. So this whole story made people dumber. Like, and your eyes are probably glazing over. You probably tuned out 30 seconds ago. But the fact is, like, probably all you heard was like, ooh, you know, Steve Descano is trying to have secret communications, when the whole story was premised on nonsense. It's just totally false, all of it. So, you know, if you to get good information, you know, you kind of have to follow advocacy groups. You know, we try to do our best to provide information, Justice Forward. So we've got social media and a website. And then there are other national groups like Families Against Mandatory Minimums. Actually, they scrapped the full term. Now it's just called FAM, FAMM. They're well worth following. The Sentencing Project is another one. Vera Institute, VERA. They're worth checking out their websites. There are a number of others. Those are the first few that come to mind. There's a publication called The Appeal, and also another one called The Inquest. These are all criminal justice reform oriented publications or nonprofits. So you can learn more factual information about what's going on in criminal legal reform.
Okay, we're about 10 minutes to 11. Next question is, do you think it's better for your organization to start with smaller, less complex laws where there might be some agreement, or do you feel like you should be going right after the bigger, most complex issues?
That's a great question. So I used to feel that the way to do it was incrementally. So you know, we didn't end up with our current situation with like one bill. It wasn't like there was like a Mass Incarceration Act of 1985. You know, the way we came to have some of the most punitive backwards laws in the country or in the world, it was bit by bit. And actually right now, like the current dynamics in Richmond are oftentimes, it's like the divided legislature that is the most dangerous from a criminal legal reform perspective, because so criminal justice reform is a bipartisan issue. There are Republicans who support it. There are Democrats who don't support it. However, Republicans on criminal legal reform, they're always going to be in lockstep. So in a situation like this, they're never going to go against their caucus to support criminal legal reform, but they will stand with their caucus to pass more punitive laws. Whereas Democrats are kind of the exact opposite, because some of them still think that these tough on crime pitches, like we're being pressed for the midterms last year, that's going to cost them votes. So they think that they've got to do something that seems like tough on crime to appease their voters. So they'll gang up with Republicans to pass tough on crime laws during a divided legislature like this. Right now, you have Steve Toscano and Kerry Delaney that are bragging about this bill they proposed that would massively diminish someone's right to cross-examination of child witnesses. And it's like totally unconstitutional. And you know the reason Toscano's doing it is because he keeps getting hammered in the media about his inability to get convictions in sex crimes cases. So he wants good press for seeming like he cares about victims of sex crime. And as a result, we're going to end with probably with a bad law for that reason. So I used to think that, like it was just as it was incremental, the way our laws got bad, that we would sort of have to peel them back the same way. We'd have to take care of one year, one the next year. But over time, what I found actually is I think some of the bigger ticket issues are much easier to message. So two issues that recently that passed, one was abolition of the death penalty in Virginia. Everybody, I don't need to take 5 seconds. You all know how you feel about that issue. I don't need to explain any of it. Also legalization of marijuana. Again, almost everybody has an opinion about that. You may not know much about the nuances of regulation and retail sales, but you have an opinion about drugs. It's the little stuff actually that's way more complicated to explain that. So I don't know. At the end of the day, I think it's a mixture of both. For me, ending the drug war is the #1 priority for the rest of humanity. Honestly, until it gets done, that's #1 on my to-do list. You probably understand why the war on drugs has been a failure. What you might not understand, though, is the individual components of it. Like, for example, I don't know, police militarization. That is a product of the war on drugs. No-knock warrants are a product of the war on drugs. Mandatory minimum sentences are a product of the war on drugs. All these bad things that reformers oppose, but those components of ending the war on drugs tend to be more nuanced and harder to explain. The overall issue is kind of easy to understand. So all that's to say, I think it has to be always a mixture of both.
Okay, what progress has there been with the Restorative Arlington initiative, particularly in setting up a diversion path for young offenders?
Yeah, gotta be honest, I've been trying to stay out of that because it got very political and there was a lot of nastiness between two different groups. My office fully supports restorative justice, and we want there to be diversion options for involving restorative justice. There's been some casework through Restorative Arlington so far. Actually, the very first case in Arlington, I think, that used restorative justice was actually a homicide case, believe it or not. It was a husband who had killed his wife when he was extra drunk. But they used restorative justice in that case, and I think it's like, I know you're never going to bring back a loved one, but the process was done the right way, and the family of the victim actually, I think, came away from the process. I mean, it's still a tragedy for them, but it helped. We want there to be more casework. Things have kind of gotten bogged down. If you are curious about the politics of it all, I'm not the one to ask. I think the county manager and the county board are the ones to ask about that, because there's another group, the CIFA, Center for Youth and Family Services, stuff like that. But they're not planning to do much in terms of diversion. And their model is more like a peer court and juvenile court. And I don't think they're going to be involved in particularly serious offenses. So we got to keep paying attention to that, keep working on it, because we want it to be useful in the cases where it's going to matter the most.
Can you speak on cash bail reform, if any, Virginia?
Yeah, this is another one where so that's become one of these like proxies for like, I hate criminal justice reform, but nobody can really explain what it means. And the thing is that it means different things in different states. So like in New York, that's the one where everybody's talking about it the most. Well, New York's bail laws are very different than ours. One component of New York's bail laws is that the judge can't consider the charged offense in determining whether the person is a danger to the community. So every other state in the country you can, including Virginia. So in Virginia, the two reasons someone could be held in detention are whether they're a risk of flight or a danger to the community. Those are considerations now, like in Arlington, and a place that has gotten rid of cash bail. At least the prosecutor doesn't ask for it. They still ask for lots of people to be held. The only thing they aren't doing is they're not asking for a money bond to be paid for the people who they think can be safely released. So that's an evidence-based approach. If you think about it, anybody who has the money to pay a secured bond, like a money bond, is going to pay it. The people who aren't going to pay it are the ones who don't have the money. So you are determining pretrial release based on somebody's wealth. And so the better practice, and it actually doesn't even result in pretrial detention decreasing that much. The better practice is just to use risk assessment instruments, get rid of the cash part, and make a decision, does this person get out or not? And if they get out, then also use evidence-based approaches to ensure they come to court once they're out and ensure they don't reoffend. So even something as simple as text message reminders, it would blow your mind how effective just sending texts, having a pretrial agency send text messages to somebody out on pretrial release, how effective that is in getting them back to court. But also in Arlington, like we have really good pretrial diversion type or treatment type options. We have a bond diversion program that connects people with serious mental illness or substance use disorder to treatment services before their trial. We have a plethora of various like community-based treatment or residential treatment. So those are the kinds of things that, that's what bail reform is. It's just getting rid of the cash part, focusing on the evidence-based approaches. And it's not just like open the doors of the jail so people can get out. It's absolutely not what it is. I hope that answered the question.
Yeah. Next question. In your opinion, do you think it's a good idea to pair social service professionals with law enforcement for domestic police calls?
Yeah. Yes, I do. I think in many contexts, any context where we can have a social, like a social services response rather than a police response, that's great. There are going to be certain circumstances, I acknowledge that it's too dangerous just for a social worker to go alone. But wherever we can have social workers respond, like if it's a trespassing offense with somebody with schizophrenia, why is a cop going to that? The person's not dangerous. The person is just confused and they're a place they shouldn't be. A domestic violence call, I'm reasonable. I think you got to expect a police officer to go to that. But yeah, I think it would probably help a lot to have a social worker go as well and to try to, use evidence-based approaches to mediating that situation or interviewing witnesses, all that sort of thing.
Are there other places around the country that are doing that?
There are places that have mobile crisis response. I don't know that they use it in the domestic violence context that often, but mobile crisis response, the one people always talk about is the Cahoots program in Portland, Oregon, which was a major success. And that is a mental health crisis responders only. It's no police involved. And so a lot of places have focused on that as a template for implementing mobile crisis response in their own jurisdiction.
Okay, we've got a number of comments here. People would like to have you come back and talk to us about your work as a public defender and what that involves. Sounds like there's a lot of interest in hearing from you again.
Sure, yeah. I'm happy to anytime.
Yep.
Well, it is 11 and I don't know, your time is tight, I'm sure, Brad, but this has been extraordinary. We still have more questions in the chat.
If you want to hang on like a few more minutes, I'm happy to answer a few more, or I can come back another time, whatever your preference.
I've got one that I'm going to take the priority to ask. How about pretextual policing, police stops, and undocumented drivers in Virginia? What's the status of that?
Well, okay, interesting you asked that. So even more like there are some federal cases, Supreme Court cases. So I already mentioned Wren versus United States, which authorized police to pull people over based on the color of their skin. But there's even like better examples of saying the quiet part out loud, and those all come in the context of undocumented immigrants. So there are cases that actually say if you're near a border, that a police officer can pull somebody over really, and there's no coded language, there's no euphemisms used. It says like if somebody looks Hispanic, you can stop them and ask them their immigration status. So that is something that is permitted in a lot of contexts. I think it's all really nuts. You know, immigration policy is a real mess all around, but you know, so frequently it is something as little as a marijuana possession charge used to be able to get someone deported in Virginia. And just crazy, you know, you've had people lived here for 10, 12 years, you know, just raising their family, working really hard. And they get picked up for something little, and all of a sudden they're in Farmville in ICE custody, waiting to be deported to Guatemala. And you're just like, why are we doing any of this? Like, there's got to be a better approach. But you know, around here, I don't think that the target like is necessarily on you know, Latino people. I'd say honestly, like with pretextual policing, it really is a like a driving while black sort of racial profiling type thing most frequently.
Very good. We're gonna stop the recording and thank you, Brad. We're getting the accolades here coming in the chat. You've done a fabulous presentation, even though you just spoke from your heart and from the cuff. So people have really stayed on this topic. I think everybody got a lot out of it, and I don't think you should underestimate our ability in this group, both to understand your work, the cases you talked about. We put a little bit in the chat. We could definitely have you for another session anytime that you can. And before you leave us, I want to thank you as a fellow Michigan grad.
Go Blue.
Also, we think you went to Columbia Law School. Is that right?
Yes.